Good morning, everyone, and welcome to our Beasley Allen webinar series. For those of you who are joining us for the first time, we are delighted to have you. And for our returning viewers, we can't thank you enough for your continued support of this program. Today, we're going to try and help you navigate cybersecurity and biometric privacy litigation. And to cover those topics, we've got two great speakers, Larry Golston and Tyner Helms. Together, Larry and Tyner are going to explain the increasing challenge of protecting networks, devices, data, and personal privacy in today's digital world. And of course, they're going to discuss the latest litigation and investigative trends for cybersecurity and biometric privacy cases. So while we're waiting on the last of our registrants to join us, let's take just a few moments to meet our two speakers. First, my friend and partner, Larry Golston, is a longtime leader in Beasley Allen's consumer fraud section. For over 20 years, Larry's practice has been focused on whistleblower litigation, retaliation claims, wage and hour litigation, sexual harassment suits, employment discrimination claims, business fraud, and class actions. During the course of Larry's career, his clients have received tens of millions of dollars in verdicts and settlements, and he's been recognized as a leading consumer lawyer, not only in Alabama, but throughout the United States. Larry has served as the president of the Montgomery County Bar Association, the Alabama Lawyers Association, and the Capital City Bar Association. So needless to say, Larry is a huge asset to Beasley Allen, and we are so happy to have him here with us today. Next, it's my pleasure to introduce another outstanding member of our consumer fraud section. That's my partner, Tyner Helms. Tyner works in our Montgomery office where he specializes in whistleblower lawsuits, class action cases, and business litigation. During his time at Beasley Allen, Tyner's played a key role in the trial and settlement of numerous complex cases. He's been named by the National Trial Lawyers to the Alabama Top 40 Under 40 Civil Plaintiff Trial Lawyers list. In addition, Tyner has been selected to the Mid-South Super Lawyers Rising Stars list. Tyner is an excellent attorney, and we couldn't ask for a more knowledgeable person to talk with us today about cybersecurity and biometric privacy litigation. So before I turn the program over to our speakers, I do need to go over just a few housekeeping notes. Today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you'll receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number. Send that again to webinars@beasleyallen.com. That'll help us ensure that you get full credit for attending today. Also, be sure to check out the events page of our website. That's at beasleyallen.com/events, as we will be adding more webinars throughout this year and into 2025. Finally, and most importantly, if you've got questions during today's seminar, I want to encourage you to use the question and answer feature located at the bottom of your screen. That's the Q&A button at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions that you, the viewer, may have. So with that, Larry, Tyner, let's go ahead and get started.
Thank you, David. Good morning. My name is Larry Golston, and I'm going to talk to you about cybersecurity litigation. You can go to the next slide, Tyner. So cybersecurity is the practice of protecting networks, devices, data, and information from unauthorized access or criminal use. In 2023, just last year, there were 2,365 cyber attacks with over 343 million victims worldwide. 2023 saw a 72% increase in data breaches, which is up from 2021, which was the previous record. And around the globe, data breaches cost, on average, about $4.9 million per person when there's a data breach or a cybersecurity incident. The most common cause of cybersecurity incidents is usually email. Email makes up in 2023 35% of your malware delivered incidents. And usually this is business email that are compromised the most, which accounted for $2.9 billion in 2023 in losses. Next slide. So in what we do in litigation, when we come across these cybersecurity cases, we generally come across them or experience them in four typical types of cases or categories. There's your data breach litigation involving PI or PII, and those are typically class actions. You have cyber fraud cases that arise under the False Claims Act as your second largest category of cases. And then you'll see securities fraud class actions, and rounding out the top four is shareholder derivative suits. And I'm going to touch upon all four of those this morning. Your common challenges that you face when you start dealing with data breach, right? The first category of cases, data breach class action suits. Your common challenges are standing, damages or harm, causation, duty, economic loss doctrine is usually raised, and arbitration. I recently have gotten, actually about a week ago, we got an order from a judge in the Northern District of Alabama who denied the defendant's motion to dismiss, and that motion raised all four, well, every one of these challenges was raised except arbitration. Going to the next slide, Tyler. Your claims in a data breach class action are and the ones that we typically bring and typically see from other lawyers are negligence per se, negligent misrepresentation, suppression or concealment, fraudulent inducement, breach of contract, breach of fiduciary duty, unjust enrichment, and you ask, typically restitution, and you ask for other injunctive relief such as a restraining order. You also have some common statutory claims such as Unfair and Deceptive Trade Practice Act statutes or UDAP statutes, and your data breach notification statutes. In Alabama, we have a catch-all under our UDAP statute that we typically assert or allege in a data breach class action. And unfortunately, Alabama is in the minority of states where our data breach notification statute does not yield itself to a private cause of action, but you can use that statute, as we have tried to use it, as a statutory per se claim or a negligence per se claim as establishing a duty on the defendants to make the clients or plaintiffs aware that a data breach has occurred. In 2023, you saw, about 5 big categories of identity theft or cybersecurity theft that arose most commonly. And that credit card fraud was the top issue. You had 46,636 incidents of credit card fraud. Other identity theft, which is a broad category, which can consume anything as people just basically adopting your name or identity. You see that a lot on these social media sites where people start a whole new site using somebody's identity. That rounded out to 260,000, almost 261,000 incidents. Loan or lease fraud was 149,804. Bank account fraud, which is a large cybersecurity harm, is 136,852 people experienced bank account fraud in 2023. And then government documents. A lot of times you have records. There was a big data breach that was announced a month ago where over 300 million, which is almost everybody in the country, over 300 million Social Security numbers were accessed or made vulnerable through a cyber attack. Your top 5 states for cybersecurity incidents or data breach incidents are California, Texas, Florida, New York, and New Jersey. And rounding out your top 10 in order are Pennsylvania, Illinois, Arizona, Georgia, and Washington. Those states combined accounted for about $1.6 billion in loss to victims due to cybersecurity and data breach incidents. Go to the next slide. Another category of cybersecurity litigation that we see and we deal with a lot, separate and aside from the class action litigation, is cyber fraud under the False Claims Act. The False Claims Act was enacted in 1863 during the Abraham Lincoln administration. And today it is the government's most potent weapon or tool to combat fraud, abuse, and waste. And we typically engage in these cases just, in general fraud, general fraudulent activities. But in 2021, the Department of Justice announced its Civil Cyber Fraud Initiative. And that initiative prioritized enforcement of the False Claims Act against companies and individuals who knowingly violate cybersecurity requirements in government contracts and grants. The liability for companies, CEOs, executives, as well as managers can be pretty astronomical as far as the dollar amounts. Next slide, Tony. So the FCA imposes liability on any defendant for knowingly presenting or causing to be presented a false claim or fraudulent record for payment. And then it also, another section of the statute imposes liability for knowingly making, using, or causing to be made or use a fraudulent record or statement that's material to a false claim. The statute itself is potent and is powerful because for each violation of the False Claims Act, and I only talked about two main sections, there are another 5 sections of the False Claims Act that can be violated. But for each violation, your penalties range currently from $13,946 to as the minimum to a statutory cap of $27,894, which, as you can probably imagine, a violation is every false claim submitted or every false record or statement that's made. So when you aggregate those false claims and false statements, that number can easily rise into the 8 or 9 figures just on penalties. But in addition to that, the statute imposes not only the amount of damage or a dollar amount lost by the government, but that amount is trebled, plus the attorney's fees, costs, and expenses are awarded. In addition to all of that, the False Claims Act also imposes liability on companies and executives for retaliating against a whistleblower who brings forth the claim. You can go to the next slide, Turner. Thank you. And so when you take that statute and its framework and apply to civil cyber fraud, you have a weapon that is potent and is very, very plaintiff friendly. Since 2021, the DOJ Civil Cyber Fraud Initiative has focused primarily on 3 areas. The first being deficient cyber products or services. That's just simply any under the government's blanket umbrella of government contracting. We have seen an increase in IT companies or tech companies offering cyber products and services to protect different computer networks and systems. And so there's been also, as everything, an increase in fraud with regard to those products and services that are being offered. The next primary category of FCA cyber fraud is misrepresentation of cybersecurity practices. There's a case right now that just recently settled called Aerojet Rocketdyne, settled out in California. And in that case, the company contracted with the Department of Defense and NASA to provide cybersecurity services. And there were certain contractual requirements that they had to meet. When the company initially applied for the bid to receive the contract, it knew that it did not have the capabilities of providing those services. And so an internal employee became a whistleblower, alerted the government that, hey, we have this contract now, but we can't provide any of these cybersecurity services under the contract. And that case wound its way through the litigation process. The government declined to intervene, but the relator and his counsel move forward with the case on their own, and it resulted in a $9 million settlement about a little over a year and a half ago now, actually about 15 months ago. And the relator received as a civil reward for bringing the case $2.6 million in reward. So these cases can be lucrative for both the plaintiff and the plaintiff's counsel, obviously. And the third category of civil cyber fraud that we see is violation of cyber incident reporting requirements. So in about 2019, most government agencies and departments have regulations that require a company who has had a data breach, whether they provide cyber security services or not, or IT services or not. Most contracts have a standard clause in them now when you do business with the federal government that requires the company to make the government aware of any cyber attacks that may have occurred against that company. In fact, the Department of Defense has a regulation and a clause in its contracts that require companies to report cybersecurity attacks within 72 hours of the attack. And there's an increase, obviously, in cyber attacks, as I've shown. And so what happens is companies will try to hide the fact that they've had a cyber attack in order to try to mitigate its own damages, or they will hide it because they don't want to reveal to the government that initially we misrepresented our capabilities. And so those claims, when you fail to meet those contractual requirements or abide by those regulations, those incidents arise to cyber fraud under the False Claims Act and are actionable. Next slide. Your next category that we don't see these as often, but we do see them from time to time, are your securities fraud, cyber breach litigation. I think one of the reasons we don't see them is because people don't look for these cases, but they can be good cases. So in a Section 10B suit that you bring regarding securities litigation, shareholders contend that they rely to their detriment on a company's material misrepresentations. And in the cybersecurity context, that can result from public statements that the company makes regarding its cyber attack preparedness or the comprehensive nature of the company's cybersecurity protocols. And what we see in these cases is typically companies, through their marketing material or through their Form 10K reports that they file with the SEC, almost invariably they will represent to the public and to their shareholders that they are, prepared, ready, capable of defending the company's networks and devices from cyber attacks. And typically, like a lot of consumer litigation, those representations are false because the companies they lag behind in the ability to keep up with today's cyber technology, and the cyber attackers are just typically always about 5 to 10 steps ahead of them. So in one case, that fairly recent case, in-rate Equifax securities litigation, that case was successfully litigated or successfully avoided a motion to dismiss because the court agreed that, hey, the company made these representations about its wherewithal and capabilities when it came to cyber security in its Form 10K and in its marketing material. And based upon that, the shareholders could reasonably rely on those representations to their detriment. And so those cases can be lucrative. Again, typically they are filed as a class action. So they're going to be in federal court most often as opposed to state court. Next slide. And the last category of cybersecurity litigation that you're going to see typically is a shareholder derivative suit. These can be tricky because there are a lot of pre-suit procedures and protocols you have to go through before you can represent a shareholder in a derivative suit. And that's why I say on this slide that, in that context of cybersecurity, you can bring a cybersecurity derivative claim against management for failing to take adequate precautions to guard against cyber attacks. But those pre-suit procedures require, for example, you have to demand the shareholder have to demand management and the corporate officers to look at the cybersecurity protocols, to look at the books to see, okay, what's going on with respect to our cybersecurity preparedness. And then obviously in derivative suits, if you can prove that such a demand is futile, then you can bypass that and proceed with litigation. But most, I cite a case here, the Palcon versus Holmes case, where essentially the case was dismissed for procedural grounds because the shareholders, they didn't go through the steps, and or they argued that, well, the steps were futile, and the court basically held that you didn't provide enough evidence to prove futility. And so you got a mixed bag on derivative suits where some are successful, such as the last case, the In re Yahoo case was successful. That case, the court pretty much kind of just bypassed the pre-suit demand issues and procedures and just said, hey, I think they can bring this case. But a lot of times, the more conservative the venue, the more apt you're going to run into problems with being able to bring a derivative suit, because it's very difficult in the cybersecurity context to establish that the company did or did not give you as a shareholder access to the records and information you needed to make an informed decision or opinion. And so if you are aware of cybersecurity incidents such as data breach, or if you have customers or clients who deal with government contracts and you come across information, whistleblower information, that these companies are not providing product services that they should be providing to the government, or not notifying the government of cybersecurity attacks, we would love to partner with you and work with you on those cases, whether it be, again, a data breach class action, shareholder derivative, securities fraud, or which is one of the things that we're working on right now, our cyber fraud, false claims act cases. We love to partner with you and love to investigate cases or claims that you think might be viable. And with that, I'm going to turn my time over to Tyner, who's going to talk to you about biometric privacy litigation.
Thank you, Larry. So again, thanks everybody for joining this morning. My name is Tyner Helms, and in a topic that's somewhat related to what Larry just spoke about, I'm going to be speaking a little bit about biometric privacy litigation. And some of you might be wondering, what exactly is biometric information? Well, simply put, biometric information or biometric data is just the unique biological characteristics that a person has that allow them to be identified. And that the use of biometric data in some respects does present enhanced security, but in other aspects it does pose additional and separate security risks that I'll talk about later. And that's because when biometric, as opposed to other personal information, when your biometric information or your biometric data is exposed, it's more difficult to remedy. And so, but with the prevalent use of that data in today's world, there are different legal frameworks that have been put in place that attempt to regulate the use, the storage, the collection of biometric information in an attempt to protect the public's right to privacy. And just biometric data falls within the general science of biometry. And just to give you the official definition real quick there, you can see it's just the measurement and analysis of people's unique characteristics as a means to identify them usually. And so biometric data falls into two main categories. You can have, there are physiological characteristics and there are behavioral traits. And for some of the main examples of some physiological traits that would qualify as biometric information, you have first and foremost, facial recognition and fingerprints are probably the most commonly used. In addition, you have iris scans, which is just the capture of the image of somebody's iris or the pupil. You have retinal scans, which uses UV light to analyze the unique pattern of the retina in somebody's eye. You also have palm prints, you have DNA. For some of the common behavioral examples of biometric information, there's voice recognition. gait analysis, which is just analyzing the unique way that somebody walks and moves their arms and legs around. Keystroke dynamics, that just measures the specific way that somebody types on a keyboard, how fast they type, the cadence with which they type at, and also it can measure the force and the pressure that somebody is applying to the keyboard as they're typing. Also signature definition. And just for comparison purposes, there's some examples of traits or qualities that would actually not qualify as biometric data or biometric information. And that's mainly because these traits aren't unique enough to one specific person in order to be able to use that trait alone to identify them. So that would be photographs, writing samples, tattoos, and then you see some medical related examples in CT scans and MRIs that would not qualify as that type of data. And why is biometric information collected and used? Well, as we just touched on, it's collected to identify people and to use that identification to control people's access to certain devices in certain areas in life. And it is used a lot in employer context where a lot of businesses where have their employees use their fingerprint or some other form of biometric data to sign in and sign out of work and clock in and out. And that's the way that they track the number of hours that any particular employee has worked. It's also used to log on and gain access to company computers, laptops, and devices of that nature. In addition, it can be used to control the access to certain areas and rooms within a building. For example, a lab or a specific office, or in a vault or something that requires additional protection. And then here, I won't spend too much in this time on this slide, but you see, aside from the employer relationship, it can be used in many areas in life just to facilitate different consumer activities and consumer transactions. And there are many devices that can be activated or operated with with your voice print or some other form of biometric data as well. And here's where biometric information and other types of personal information really differ. It differs, with regard to the risk and concerns that are involved, because when other types of personal information are exposed, it's there is damage that it will certainly occur, or that exposure presents the risk of damage. But you can change your password. You can shut down a bank account if your bank account number is compromised. But with regard to biometric information, you can't really change your facial template. You can't change your fingerprint. You can't alter your DNA. And so once it's out there, your anonymity is gone. And that's what presents the separate risk and concerns. And then just to drill down on that a little bit, when a company without authorization is collecting people's biometric data, there's a risk that that company gets hacked. Okay, and then if that company is hacked, then an outside bad actor now has your biometric data, and then they can use that to gain access to certain things that they're not supposed to have access to. And then just in general, if a company is collecting biometric information without people's consent, then using that information to their benefit, whether they might be selling the data to a third party who then uses that data for specific targeted ads towards you, that just at a fundamental level violates people's idea and assumptions about what their privacy rights are. So that's another concern that people have. So for legislation and regulations that are out there, there is no single federal framework or federal statute that completely addresses biometric data out there. One reason being is that there's just no consensus around what actually qualifies as biometric information, and how to regulate it, much less what specific government body or agency would be designated to enforce those regulations when they're being violated. So there's that, and also we're always doing a balancing act, right, between convenience and privacy, because the reality is that the world we live in now, there's just a lot of activities, a lot of transactions that are just way more efficient, way more convenient, and just overall easier with the use of biometric information. And so you're always weighing that against your privacy when they're deciding how to regulate this type of conduct. And now, as far as the state laws that are out there, there are three states that have laws that specifically regulate biometric data. Those are Illinois, Washington, and Texas. Aside from those, there's a lot of states out there that have their own data breach law or a data breach notification law, and in some of those states, the definition in the law of what personal information does include biometric data in some cases, and so that's another area where the collection of that information can come into play. And here's just specific titles and citations for your reference of the three states that have biometric specific privacy acts. Now here's the Texas law. So just to give you an idea of what's out there, the Texas statute, you can see it has a pretty standard definition of biometric information or biometric identifiers. You see the standard characteristics, voice prints, fingerprints, then the retinas and iris scans. And the main prohibition in that law is that a person or a company, they are not allowed to capture any biometric information of an individual for commercial purposes without that individual's informed consent. And so, and Washington's law is very similar to the Texas law. And the important thing to note about those two states is that there is no private right of action. A private citizen who has their data collected without their consent cannot initiate a lawsuit under this law. It can only be done by the state itself through the Attorney General's office. And in contrast, we have the Illinois, the Biometric Information Privacy Act. Just for ease of use, I'm just going to call it BIPA during this presentation. But again, it has its own pretty standard definition of biometric identifier. And interestingly enough, it also proceeds to have a list of certain traits that it specifies as not qualifying as biometric information. So you can see the photographs and written samples and things of that nature. Again, the main thing that it forbids is a prohibition against a company collecting, storing, selling any Illinois citizen's private biometric data without that person's informed written consent. And when that statute is violated, it carries with it a civil penalties of $1,000 per negligent violation, and then $5,000 for each willful or reckless violation. And because the BIPA is it's the most commonly used law out there, and it has the most filings under it because it has that private right of action, I'm just going to give a few examples of some of the significant decisions out there under that law. And the first one would start with Rosenbach versus Six Flags Entertainment Corporation. In that case, the plaintiff sued Six Flags because the plaintiff alleged that through its use of Six Flags' use of its repeat admission entry passes, it collected the plaintiff's fingerprints without the plaintiff's authorization in violation of Illinois' BIPA. And the big dispute in that case was that plaintiff only alleged the statutory violations. He didn't allege any further injury other than that. And so the Illinois Supreme Court ruled that that was enough. It said that the allegation of a mere technical violation and the mere capture of biometric data without the individual's consent is enough for actual injury under that law, and therefore the plaintiff had standing. So the second case is Cawthron versus White Castle Systems. Yeah, as I mentioned a minute ago, the Illinois BIPA carries with it a statutory penalty of at least $1,000 per violation. Well, what this case cleared up was that the Supreme Court in Cawthron clarified that not only is it a violation the first time that a company collects that data without the individual's consent, but each and every time after that is also a violation. So you can imagine how that decision has a big impact on the amount of damages that can be at play in these types of cases. And then the third case, so for a number of years, the Illinois BIPA was operating under two different statutes of limitations that could apply, depending on what one specific type of claim under the law that a plaintiff alleged. And so in Timms versus Black Horse Carriers, the Illinois Supreme Court was asked to decide between the two, to just pick one and decide between two different statutes of limitations, one being a one-year statute of limitations, or the Illinois' catch-all 5-year statute of limitations. And the court did select one that, in a unanimous opinion, the court decided to ruled that the catch-all 5-year statute of limitations applies to the Illinois BIPA cases, no matter what type of claim somebody alleges under that law. And so that, drastically for Illinois citizens, that drastically expands the time frame with which they have to file a claim for this type of conduct if their data is collected without their consent. And so for settlements and verdicts out there, again, I'll stick with the Illinois BIPA. The largest one to date was against Facebook, and it centered around Facebook's former tag suggestions feature that it had in its app. The way it worked was that, and was alleged, was that Facebook, through the secretly had facial recognition technology, and so if you are a Facebook user, the technology could take your profile picture or any picture on your account, make a facial template out of that picture, which was associated with your name, your profile, then store that template in its database. So when somebody else that you were Facebook friends with, say, post a picture of you and several other people, its technology can then analyze all the faces in that picture, run it through its database, and if there is a match on a facial template it already had stored, then the tag suggestions would then, at that point, suggest that you tag those people that were named in the picture. And so that case, eventually, it was a class of Illinois users filed in Facebook's headquarters in the Northern District of California. It settled for $650 million. And it involved a record of more than 1 million participants of Illinois citizens in making a claim under that settlement. Another big, large jury verdict in this case was Rogers versus BNSF Railway. In that case, it was a class of truck drivers who would use their fingerprint to gain access to the rail yard in order to drop off and pick up loads of goods that they were hauling. And the truck drivers alleged that BNSF collected that fingerprint data without getting their written consent. And so that case was tried to a jury, and the jury found that there was over 45,000 separate violations. And adding up the violations with the civil penalties, it arrived at a verdict of $228 million. Now that verdict was vacated and the trial was set for a new trial. But nevertheless, it did end up selling before the new trial for $75 million, nonetheless. And then the last one is the case that was alleging the same activity under Facebook's tag suggestions as the one I just mentioned a second ago. Only this time it was brought by the state of Texas under both the Texas State Biometric Privacy Act and also Texas State Deceptive Trade Practices Act as well. And so, you know, combining the penalties with the State Biometric Information Act and also the consumer protection law that it alleged, which also carried a civil penalty of up to $25,000 per violation. So facing the even more enormous penalties, Meta ended up settling with the state of Texas for also an enormous amount of $1.4 billion. And that begs the question of what other causes of action might come into play for this type of behavior. So, like, I think the Facebook case is a good example of that. Not only were the laws that specifically regulate biometric data violated, but Texas also made allegations of violations of its Consumer Protection Act. So that the thought is that there's potential for causes of action under other states' consumer protection acts for this type of behavior, as well as potentially state data privacy acts, and maybe even other different common law causes of action out there like unjust enrichment as well. So I think that's where this area of law may be potentially heading. And we, like Larry said, whether it's a case like this or a data privacy type of case, we'd love to work with you on those. If anything ever comes to mind or comes across your desk, feel free to reach out to us. But I think that is it, unless we have any questions that Davey wants to revolve.
Thank you, guys. That was enormously helpful. And on behalf of all of our viewers, I want to thank Larry and Tyner for that great presentation. I'm always amazed by the work that you guys do. It's always informative to hear from you. We have received a few questions during your talk, and if you'll allow me, I'd like to present them to you and get a little bit of feedback from you. And to the extent we run out of time today, well, we'll send a typed response to you after the program. So our first question, I think, is directed at Larry. Larry, Mark asks, what is P1 and P2? Can you give us a bit more detail on that?
Yeah, so personal information is PI, and personal identifying information is the P2, I think is what he's referring to. The slight distinction is personal information is just, it can be anything that generally identifies a person, such as your age, or, I think if you're on Facebook or some of these social media sites, you put in like where you went to school, where you live, the city. That's kind of general personal information. Your personal identifying information will be things that, social security number, your obviously your name, your bank account information, things like that identifies not just, this person is in a general locale or a general group of people. This is the actual person. This is David Byrne or Larry Golson or Tyner Hill. Your health, I'm sure people have heard of HIPAA. Your medical information, right? Like you have a medical ID, you have a social security number, you may be assigned an identification number, and then you have all this health information related to your treatment or your prognosis or diagnosis. That would be more PI, personal identifying information.
Okay. Let me ask you this question, Larry. What is the number one way that people like me who are unfamiliar with this topic can take steps to protect our personal information or that personal identifying information?
Good question. And so one of the things I talked about was one of the number one ways that we call them threat actors, the cyber attackers. One of the number one ways that threat actors gain access to your device or your network is through phishing attempts, right? Phishing or malware. So let's talk about those. Phishing is just like I said, the emails they send you out, and the email is arranged in a way that it's personalized. It purports to ask you questions that you may know, like, wait a minute, this seems pretty personal, seems like somebody knows me, and then you start answering that email. Well, when you do that, when you open an attachment or something like that in a phishing attack, that's how the bad guys or the threat actors gain access to your network, your devices, and then they can lock you down. I'm sure people have heard of ransomware. That's how ransomware usually works. Malware, similar concept, but it's less personal. It's less targeted. Like phishing is more targeted, right? Like it's hey, David, you didn't pay your bill to DirecTV this month, and you're up to, you could be getting a late fee. Click on this link. That's more of a phishing attack. Malware is more of when you go to certain sites. I'm generalizing here on all these things, but mostly when you're on your devices and you go to a site, that site can be affected, or you're using a device and you use a password that is not necessarily the best password to be used, and the hackers hack into your account. They can install malware on your account through you just using keystrokes. Those are the two most, for individuals, those are the two most prevalent ways that we see where threat actors gain access to your networks or your devices. And unfortunately, the third way, companies are getting a little better at it, but the third way is, and there's really no way to avoid this, is this your consumer interactions with your normal box store, right? or even your cyber store, even like Amazon. You years ago, back in 2013, I think 2014, we were involved in the Target class action, and that was just simply people went to Target, bought products, bought goods, swiped their card or used their card at the register, and they ended up having their bank account compromised or their financial information compromised because the threat actors had actually gained access to Target's systems through their register systems.
Most of our viewers, I think, Larry, are attorneys. They're part of a law firm. They have clients, and from time to time, these phishing attacks, malware attacks can bring about a loss or compromise of client-related data. To the extent something like that happens to us as attorneys, and of course to our clients, what obligation do we have to reach out to the Bar Association for help? Do we have an obligation to seek assistance from the bar in that instance?
I would say yes, and more, and I'll say that because actually about a year and a half, 2 years ago now, my years run together, but I think it's 2022, the state passed the Data Breach Notification Act. So if your firm's computer systems or networks are compromised, you have an obligation to notify your clients, number one. I think you want to reach out to the bar to protect yourself. I think that's always a good idea to notify the bar, because one of the things that can end up being an ethical problem for you is if you didn't have cybersecurity protection to try to prevent the threat actors from gaining access to your file. So you asked a minute ago, one of the things we can do, I would say you have to invest in IT help, whether you have an internal IT person or you get third-party cloud service. You got to invest in that. You also have to, in my opinion, there are more and more policies now being written, cyber security policies. I think it would be very, very wise to invest in one of those policies. David, we have a case right now that we recently filed for a company in Alabama who they had the protections I just talked about. They hired a third-party IT company, and the third-party IT company was attacked by threat actors. And they did everything right. They had the backups to their system, but now even their backups are compromised, right? And so they really, this is a multi-million-dollar business, 9-figure business, and they can't function right now because they have no access to their account receivables. they don't know, what's going in, what's coming out, because the ransomware guys have locked them down. So the good news, I bring that up to say they have an insurance policy. And so in addition to our firm working to go after the defendants who allowed their networks to be compromised, they have another team of lawyers who are out there helping to protect, get them insurance coverage and try to figure out whether they have to pay the ransomware or not, the ransom or not, and or how this attack occurred, so they maybe can go back and mitigate some of this damage. But as for our fellow practitioners, lawyers, we definitely have to get the insurance. We got to get the IT protection. I think you got to have backups. You got to back your systems up routinely and keep them on different servers. Like don't have everything on the same network, so that if you are attacked, your backups, you can kind of go back to work the next day and business can function and function.
Well, we got a related question in from Frederick. Frederick asked, is a virtual private network, or VPN, effective in protecting personal information and or personal identifying information? What do you got?
It can be. It all depends. It can be, and I hate to hedge, but these guys, these threat actors are so good now. Like it depends on, I guess, the type of VPN you use. I personally would always have a backup plan. Like you can use a VPN to do business or communicate, but I wouldn't leave. I wouldn't put all my eggs in one basket, so to speak. I wouldn't have all my communications that way, all my client access or meetings or anything. I wouldn't do it all that way. Because right now we have another company we've sued, and they specialize in VPN, and they put out patches to try to stop these companies. These threat actors, but the threat actors have accessed some of their software. So you have to be very careful, even using a VPN.
Well, Tyner, we've also gotten a question from one of our viewers, William, and it's a substantive question. He asked, can consent to use biometric info, like under the Texas statute, be obtained by an adhesion, or have to opt out type consent, or a click through, or does it require an affirmative individualized consent by each person?
Yeah, so I believe the answer is yeah, it can be obtained through that. There's some platforms that use biometric information, like you mentioned, do offer an opt-out. Facebook did at one point for its tag suggestions feature. You could opt out of the facial recognition technology, but usually, that these companies will have, if it's an online transaction, the company will have a lot of times their terms and conditions and also a separate privacy policy that will state, if you use this product, you're consenting to our collection or use of your biometric data. Now that they're supposed to also have policies that they state in place for, how they store that data, what they use it for. But yes, that, from my understanding, that is enough for consent in most cases.
Got another substantive question from William, and he asks, when health-related data, HIPAA-related data is hacked, like from, say, a hospital, can claims be brought both under HIPAA and other claims generally used in a cybersecurity breach case? In other words, can you proceed under both privacy pathways?
Well, typically HIPAA doesn't provide a private cause of action. So you can get creative and argue that HIPAA creates a statutory duty and bring common law negligence claims. But typically in the medical or healthcare industry, you would bring those claims just a class action, probably on behalf of everybody affected, and you would assert mostly, depending on where you live, in the Southeast, you would assert mostly common law claims, and you would use HIPAA as an argument for your negligence per se claim, saying it established a duty. But even then, it also depends on the type of cybersecurity or data breach that occurred, right? Like if If it's ransomware and the company reasonably did what they could do to protect the information, HIPAA may not be the main argument. The main argument just may be your cybersecurity protocols were, insufficient. But in contrast, I guess you should say in contrast, if it's because you have nurses, doctors, medical personnel, and they allow their laptop or their login credentials to be compromised, now you would get more into a situation where, hey, you didn't take care of this health information properly, and it kind of just morphs into two different causes of action, both of which probably being common law claims.
So I have a question for our viewers who might be contacted by victims of, say, a cybersecurity breach or a biometric privacy violation. What steps, if any, should they take to preserve and try and obtain evidence related to the incident?
Well, with respect to cybersecurity, the first thing you want to do is find out whether that client has gotten a notification, right? Like nearly every state in the union now has a data breach notification law. So you want to figure out, did the defendant or whoever it is they're doing business with provide them a notification, and then get a copy of that, because they should provide information in the notification as to what happened, when it happened, and give some general, they're usually more general than specific, indication of what happened. That's going to be helpful in our end in working with firms like ours to start putting together the pieces to the puzzle of what end up happening and what kind of data breach we're dealing with and what kind of litigation you can pursue. You also want to make sure. I had a case recently where company was ransomware attack, malware, and they wanted to send me information from their server, and I'm like, no, don't do that. Like, so make sure that you get printout information. Don't have them email you. If their email is already compromised, you definitely don't want them to email information from that compromised email address to you in your firm, because it could be like a Trojan horse type of malware, and just gets into your network. So you want them to bring you physical copies of the notification letter and things of that nature. And then you want to advise them also, they probably need to change passwords, go get new debit credit cards, so on the customer end that they're kind of protected.
Well, we've got time for one last question. It comes from Mark. Mark asks, in comparative negligence states, when suing the company that was breached, are those defendants able to lessen their liability by alleging that the hacking criminal should be on the jury verdict form as well?
Well, I mean, in theory, yes, but in the cases that I've seen, most of the time, that's not a practical issue that we have to worry about, because most of the time, believe it or not, most of the time, the entity that was hacked, there was some clear problems on their end. Like we've not seen cases where, they basically had the cybersecurity equivalent of Fort Knox and they still were breached. Usually what happens is there is some clear, almost borderline reckless behavior of the company where they used basically really poorly congregated identification numbers. They had bad login credentials. And a lot of times it's just as simple as, what usually happens is some employee there in the company got compromised. They answered that, about 15 years ago, David, was the Nigerian email, Prince email, where, hey, you got $1 million in the bank, just respond. Now it's more like, hey, this is your credit card company, and we think we may have been compromised. We need you to log on and click on this thing to communicate with us, and people get hacked. So, that's how it usually happens. And so practically speaking, usually you can find that the defendant, the main defendant that got hacked or had the intrusion was really at fault. In addition to the threat actors who
right. Well, Larry and Tyner, I can't thank you enough for your time today. I know all of our viewers appreciate it. And for those of you who may have missed our earlier announcements, By the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys who are participating by phone, please email us your name, phone number, and state bar ID number. Send that again to webinars@beasleyallen.com. That will help us ensure you receive full CLE credit for today's program. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the remainder of this year and into 2025. Thanks to all of you for joining us today, and thank you for supporting our Beasley Allen webinar series. Have a great day.